On the 31st of October 1883, in a house in Honolulu, a dying woman picked up a pen and signed 11 pages of ruled legal paper. She was 51 years old. She had no children. She was the last direct descendant of Kamehameha the Great, the chief who had brought the Hawaiian Islands under a single government 70 years before, and when she died, the line was going to end with her. What she signed that afternoon gave away roughly 375,000 acres of Hawaii. That is about 1 acre in every 9 in the entire archipelago. It included the ground under Waikiki. And it went, all of it, into one trust, which still holds almost all of it today, more than 140 years later, which makes that trust the largest private landowner in the state of Hawaii, and, for a while in the 1990s, the richest charitable trust in the United States of America. But the acres are not the important part of that document. They are not what almost destroyed it, because the 14th clause of the will answers a different question, and it answers it in one sentence, in the flat administrative language of a woman tidying up a detail, not what should happen to the land, who should decide what happens to the land, and then, half a line later, who should decide that. She got that sentence wrong. She got it wrong for a reason that no person alive in 1883 could reasonably have anticipated, and it took 114 years for the mistake to go off. Start with who she was, because almost nothing about this makes sense without it. Her name was Bernice Pauahi. She was born in Honolulu on the 19th of December 1831 to Abner Paki and Laura Konya, both of them high-ranking ali'i, the chiefly class of the islands. Through her mother she descended directly from Kamehameha I. To understand what that meant in 1831, you have to understand what Kamehameha had done. Before him, the Hawaiian Islands were not a country. They were a set of independent chiefdoms that fought each other, sometimes constantly, over roughly 25 years through warfare and negotiation, and one famously decisive campaign. Kamehameha brought them under one authority and founded a kingdom that would be recognized by Britain, France, and the United States. His descendants ruled that kingdom, and the family's landholdings were correspondingly enormous, because in the older Hawaiian system land was not owned the way Europeans owned land. It was held in trust by chiefs on behalf of the people who worked it, and ultimate authority over all of it rested with the ruling chief. That distinction is going to matter enormously later, so hold on to it. In the system Pauahi was born into, the idea of a person permanently owning a piece of ground and being able to sell it to a stranger did not exist. Pauahi was given, as a small child, into hanae, the Hawaiian practice in which a child is raised by relatives other than the birth parents. It was not abandonment. It was a way of binding families together and of placing a child where they would be best raised, and it was completely ordinary among the ali'i. She was sent to the chief's children's school, later called the Royal School, run by American missionaries. It was set up to educate the young ali'i who were expected to govern, and the roster of her classmates is essentially the list of everyone who would rule Hawaii for the next 50 years. 4 future monarchs sat in that schoolroom with her. So this was a young woman raised at the centre of a kingdom, educated in English and in Christianity by New Englanders, fluent in both worlds and fully at home in neither one exclusively. It is worth naming the people in that schoolroom, because their fates are the argument of her entire will. Alexander Leholiho, who became Kamehameha IV, died at 29. His only child, Prince Albert, died at 4 years old, and the boy's death broke his parents. His mother, Queen Emma, spent the rest of her life in works of charity and never remarried. Lot Kapuaiwa, who became Kamehameha V, died at 42 without an heir, which is the death that put the throne in front of Pauahi. William Charles Lunalilo, elected king after him, died at 39 after reigning barely a year. Victoria Kamamalu, the heir apparent for a period, died at 27. Bernice Pauahi Bishop herself died at 52, which made her one of the longer-lived people in that classroom. David Kalakaua, who succeeded Lunalilo, made it to 54. His sister Liliuokalani, the last monarch, lived to 79 and outlived her country by 24 years. That is not an ordinary run of luck. That is a small group of well-fed, well-housed, well-doctored people at the top of a society dying young one after another over a few decades, for the same reason everybody else in Hawaii was dying young. Pauahi did not have to read a report to know what was happening to her people. She had gone to school with them, And then, at 18, she did something her parents did not want. Charles Reed Bishop was an American. He had been born in Glens Falls, New York in 1822, an orphan raised on his grandfather's farm, and in 1846 he had boarded a ship bound for Oregon with a friend intending to make a life on the American frontier. The ship stopped in Honolulu. Bishop got off, looked around, and never got back on. He took a job in the customs house. He learned the business of the port and then the business of money, and he was very good at it. He would eventually found the bank that carried his name, and that exists today as First Hawaiian Bank, one of the oldest financial institutions in the Pacific. He met Pauahi and asked to marry her. Her parents objected firmly. She married him anyway, in June of 1850, in a small ceremony at the Royal School, without her family present. They were married for 34 years. By every surviving account, it was a close marriage, and it produced no children, which is the fact that eventually determines everything else in this story. Now, the other thing you need to know about Bernice Pauahi Bishop is that she was offered the throne of Hawaii and turned it down. In 1872, Kamehameha V was dying. He had no heir. He was the last of the Kamehameha line to rule, and on his deathbed he asked Pauahi to succeed him. She refused. The reasons given by those who knew her come down to temperament and to a judgment about her own suitability. She was not a political person. She did not want the throne. Accounts of the scene have her telling the dying king that there were others better fitted for it. Whatever the reason, the effect is a matter of record. The Kamehameha dynasty ended as a ruling house. The legislature elected Lunalilo and then Kalakaua, and the woman with the strongest hereditary claim in the kingdom went home to private life, which means that when she sat down 11 years later to write a will, she was not disposing of a throne. She was disposing of something she considered more consequential, and she had already demonstrated in the most public way possible that she was capable of making an enormous decision on her own judgment and refusing to be moved. Now, the land. Because the number at the front of this story is truly strange, and the way it got into one woman's hands is one of the most consequential episodes in Hawaiian history. Go back to 1848. By the middle of the 19th century, the Hawaiian kingdom was under sustained pressure. Foreign powers were circling. Foreign residents wanted the ability to own land outright, which the Hawaiian system did not permit, and their governments were making that want into a diplomatic matter. Britain had briefly seized the islands in 1843 before handing them back. The kingdom's response under Kamehameha III was to convert the entire land system of Hawaii into something recognizable to Western law. That process is called the Great Mahil, and Mahil simply means division. What it did, over a period of years starting in 1848, was to divide the land of the kingdom into categories. Crown lands, held by the monarch, government lands, held by the state, and konohiki lands, distributed among the chiefs, roughly 245 of them, who could then claim them as private property. The stated intention was protective. Convert customary tenure into legal title, so that Hawaiians would hold their land under a system the foreign powers were obliged to respect. The actual result over the following decades was catastrophic for ordinary Hawaiians, because the commoners, the makainana, who had worked the land for generations, had to file individual claims for their own parcels under the Kuleana Act of 1850. That required knowing the process existed, appearing before a commission, describing boundaries, and often paying for a survey. In the end, out of something like 4 million acres in the kingdom, the makainana received in the region of 28,000, less than 1%. Meanwhile, the chiefly lands were now alienable, which is a lawyer's word meaning sellable, and over the next 50 years an enormous proportion of them passed to sugar planters, ranchers and corporations, sometimes through sale, sometimes through debt, sometimes through mechanisms that were legal and are not defensible. There is a further piece of it that is less often mentioned and that made the outcome close to inevitable. 2 years after the division, in 1850, the kingdom passed an act permitting foreigners to hold land in fee simple. Before that, they could not own outright, so the sequence is this. First, in 1848, customary land tenure is converted into private title. Second, in 1850, ordinary Hawaiians are given a narrow and difficult window to claim their own parcels. Third, in the same year, foreigners are made eligible to buy. Land that had been held under obligations to a chief and to a community was now an asset that could be sold to anybody, in a cash economy that most Hawaiians had almost no access to, at a moment when the population was collapsing and families were losing the members who worked the ground. Within a generation, the sugar corporations held enormous tracts. Within 2, a handful of companies known collectively as the Big Five effectively ran the economy of the islands. Historians disagree, sometimes sharply, about intent. Some read the mahili as a defensive measure by a king trying to secure Hawaiian title against foreign powers, which failed. Others read it as a transfer engineered by foreign advisors who understood perfectly well what the outcome would be. There is evidence for both, and Kamehameha III's own recorded misgivings support the first reading while the identity of the men drafting the legislation supports the second. What is not in dispute is the result. A people who had held all the land held almost none of it within 50 years. Bernice Pauahi Bishop's fortune is a product of that system. It is important to say that plainly. The 375,000 acres in her will exist as a private estate because of the mahel, and the same process that concentrated them in her hands dispossessed the great majority of Hawaiians. She did not design that system. She was a child when it began. But her will is only possible because of it, and any honest account of this story has to hold both of those facts at once. Now, how it came to her specifically. Pauahi inherited from her father Paki and her mother Konia. She inherited from her aunt Akai and her uncle Mahuni. Those were substantial holdings on their own. And then, on the 24th of May, 1883, her cousin died. Ruth Kealakalani was one of the most formidable figures of the era. She was enormous in physical presence, spoke Hawaiian by preference, and largely refused to use English, and held to the older customs at a time when the court around her was anglicizing rapidly. She was also, by inheritance, staggeringly wealthy. Her lands had come to her from her father Matayo Kekwanawa, from her half-brother Lot Kapuaiwa, who reigned as Kamehameha V, from her half-brother Moses Kekwaiwa, from her half-sister Victoria Kamamalu, and from her Hanai son William Pitt Leleahoku, which is to say that the land holdings of most of the senior Kamehameha line had converged through a series of deaths into one person, and Ruth Kealakalani left them to Pauahi, roughly 353,000 acres in a single inheritance, 5 months before Pauahi signed her will. Kamehameha Schools today puts Pauahi's total personal estate at 485,563 acres, so a number that has been in the family for a century arrives all at once, in the hands of a woman with no children, who has already refused the throne, and who is 51 years old and about to find out that she is ill. That is the situation in which the will gets written. And there is one more thing in the situation, and it is the thing that explains why the will says what it says. Her people were dying. The estimates vary, and they vary a lot, but the scale is not in dispute. Before sustained Western contact, the population of the Hawaiian Islands is estimated at somewhere between 300,000 and 800,000 people. By 1893, it was around 40,000. That is a collapse of somewhere between 85 and 95% over roughly a century, and the cause was overwhelmingly disease: influenza, measles, smallpox, whooping cough, venereal disease, tuberculosis, illnesses that arrived on ships and moved through a population with no acquired immunity to any of them. Pauahi watched this happen for her entire life. Not as a statistic, as a series of funerals. Her classmates from the royal school died young repeatedly. Kamehameha, the fourth's only child, died at 4 years old. The royal families of the kingdom lost children at a rate that reads, in the archives, like a list of catastrophes, and she had no children of her own to leave anything to. So consider the question in front of her in the autumn of 1883. She holds close to 500,000 acres. She's the last of her line. Her people are, by any reasonable reading of the numbers, disappearing, and she does not believe she's going to live much longer, because she is right. What do you do with that? You could give it to your husband, and she did leave him a great deal, including Molokai Ranch and a life interest in her Waikiki lands. You could give it to the crown, but the crown was Kalakaua, and it was not stable, and within 10 years there would not be a crown at all. You could give it to the church. Or you could try to do the one thing that might change the trajectory, which is to educate the children who were left. That is what she chose. and she wrote it down in a document that is, when you actually read it, a lot stranger and more human than its reputation suggests. Let me take you through it, because most people who talk about this will have never read past the famous paragraph. It opens conventionally, being of sound mind and memory, but conscious of the uncertainty of life. And then it starts, not with the schools, and not with the land, but with a list of very small gifts to specific named people, $200 each to 7 girls and women who had been named after her. Her husband's niece in San Joaquin County, California, the daughter of a Honolulu lawyer, a girl in San Francisco, Annie Pauahi Cleghorn, Pauahi Judd, $200 apiece to people whose only connection to her was that somebody had liked her enough to give a baby her name. Then $200 each to 4 married women. Then $500 each to 4 more, and in that clause she specifies that it is to their sole and separate use, free from the control of their husbands, which in 1883 is a deliberate legal instruction and not a throwaway. Then a series of provisions for people who worked for her, and this is where it stops sounding like a legal document. $30 a month for life to Kahakwakoi and her husband, plus a piece of land at Kapalama. $40 a month for life to Mrs. Kapoli Kamakau, and then this, $30 a month during her life to, in the will's own words, my servant woman Kaya. There is no other information about Kaya in the document, no surname, no description. A woman who worked in the house, provided for by name for the rest of her life, in the will of the richest woman in the kingdom, sitting 5 clauses above the disposal of 500,000 acres. There are house lots left for life to a man called Kapea and a woman called Auhea. There is $5,000 for repairs to Kauaihau Church, and another $5,000 for the Kauaihau Family School for girls. And there is a bequest of 2 large land divisions on Kauai and Hawaii Island, for life, to a woman the will identifies as H.R.H. Liliuokalani. That is the future queen. In 1883 she is a princess. 10 years later she will be the last monarch of Hawaii, and will be removed from the throne by a group of men in Honolulu, and one of the trustees named later in the same will is going to be part of it. We will get there. Then comes the 13th clause, and the tone changes completely. I give, devise, and bequeath all of the rest, residue and remainder of my estate real and personal, wherever situated unto the trustees below named, their heirs and assigns forever, to hold upon the following trusts, namely, to erect and maintain in the Hawaiian Islands 2 schools, each for boarding, and day scholars, one for boys and one for girls to be known as, and called the Kamehameha schools. That is the sentence that created the institution. And then, having created it, she immediately starts putting limits on the people who will run it, and the limits are worth going through one at a time because they tell you exactly how much she trusted human nature. First, a spending cap. Her trustees may spend on land, buildings, fixtures, furniture and apparatus whatever amount they think best, but not more than 1/2 of the fund that comes into their hands. Half, no more. The rest has to be invested, and the schools have to run on the income. Second, the beneficiaries. The trustees are to devote a portion of each year's income to the support and education of orphans, and others in indigent circumstances, giving the preference to Hawaiians of pure or part Aboriginal blood. Note the exact structure of that, because it has been litigated for decades and it is not what most people assume. The will does not say the schools are only for Hawaiians. It says that a portion of the annual income must go to orphans and to the indigent, and that in that provision preference goes to Hawaiians. Third, the curriculum, and here she is very specific about what she wants and what she does not. She desires her trustees to provide, first and chiefly, a good education in the common English branches, and instruction in morals and in such useful knowledge as may tend to make good and industrious men and women. And she says that instruction in the higher branches is to be subsidiary to that. She's describing a practical school, reading, writing, arithmetic, character, and a trade. Not a finishing school and not a university preparatory academy. That priority is going to be quietly abandoned over the next century, which is its own argument. Fourth, and this is the one almost nobody mentions, she builds in transparency. Her trustees, she directs, shall annually make a full and complete report of all receipts and expenditures, and of the condition of the schools, to the Chief Justice of the Supreme Court, or other highest judicial officer in this country, and they shall also file before him annually an inventory of the property in their hands and how it is invested. And then she adds 7 words that are the most remarkable thing in the entire document. And to publish the same in some newspaper published in said Honolulu, print the accounts in the paper every year where anyone can read them. In 1883, that is an extraordinary instruction. There was no legal requirement for a private charitable trust to publish anything. She wrote it in herself, unprompted, because she wanted the whole thing done in the open. Remember that clause. In 114 years, when the trustees are reporting the value of the estate at about $2 billion, while the land on Oahu alone is assessed at nearly $5 billion, and their stake in one investment bank is thought to be worth up to $3 billion, somebody is going to point at that sentence. 5th, she requires the teachers to be Protestant forever, and then immediately adds that she does not intend the choice to be restricted to any particular sect of Protestants, which is a woman trying to prevent one denomination from capturing her school, and which will eventually put the trust in court against the federal government. And then the 14th clause, she names her 5 trustees, her husband, Charles R. Bishop, Samuel M. Damon, Charles M. Hyde, Charles M. Cook, William O. Smith, all of Honolulu. A majority of them may act in all cases. 3 of them at least must join in any act, and then comes the sentence. I further direct that the number of my said trustees shall be kept at 5, and that vacancies shall be filled by the choice of a majority of the justices of the Supreme Court, the selection to be made from persons of the Protestant religion. That is it. That is the whole thing. 38 words about an administrative procedure, sitting in the middle of a document that everybody remembers for a completely different paragraph. She signed it. 2 witnesses signed under her, F. W. McFarlane and Francis M. Hatch, attesting that the foregoing instrument, written on 11 pages, had been signed and declared in their presence. She added 2 codicils in the following year, adjusting some provisions, and on the 16th of October 1884, Bernice Pauahi Bishop died of breast cancer at the age of 52. Now, let us look properly at that sentence, because everything that happens for the next century and a half is downstream of it. The problem she was solving is a real one, and it is one of the oldest problems in the law. You are about to be dead. You're handing an enormous amount of property to 5 people. Those 5 people will eventually die too, and someone will have to replace them and then replace their replacements forever. So who picks? Look at the options actually available to a Hawaiian woman in Honolulu in 1883. Family. She had none in the relevant sense, that was the whole premise, and the family she did have was the royal house, which had just passed out of her line entirely. The trustees themselves. This is the most common answer in trust law then and now. Let the surviving trustees choose the new ones. A self-perpetuating board. She did not do that, and her reason is not hard to reconstruct. A self-perpetuating board answers to nobody. 5 men who choose their own successors will, over generations, tend to choose people like themselves, and there is no external check on it whatsoever. She had a spending cap and a publication requirement in her will. She was clearly thinking about the possibility of misconduct. The Crown. The monarchy was in trouble, and any competent observer in Honolulu could see it. Kalakaua's reign was politically turbulent. The sugar planters were increasingly assertive, and there was open talk about the kingdom's future. Attaching her trust to the throne meant attaching it to whatever happened to the throne, which, as it turned out, would have been a disaster, because within 15 months of her death the crown would face an armed constitutional crisis, and within a decade there would be no crown at all. The church. Her will is emphatically Protestant, but the same clause that requires Protestant teachers refuses to specify a sect. She did not want a denomination running her schools, so she looked at the institutions of the Hawaiian kingdom and picked the one that was designed, structurally, to be insulated from everything else, the Supreme Court. And in 1883, that choice is not naive. It is close to the best available answer. The Supreme Court of the Kingdom of Hawaii was a small professional bench. Its justices served long terms. They were removed from the immediate pressures of the legislature and of commerce. They were, in the specific sense that mattered to her, the people least likely to be bought, because they were the people with the least to gain. She was not delegating a decision to a group of politicians. She was delegating it to the one body in her country whose entire institutional purpose was to be indifferent to who was asking, and she doubled it. She did not only give the court the appointment power, she also made the Chief Justice the recipient of the annual accounts. Both of her safeguards run through the same door, which is why this story is not, at bottom, a story about greed. Greed is common and greed is boring. This is a story about what happens to a safeguard when the thing it was anchored to changes underneath it. Because the fact is that Bernice Pauahi Bishop could not have known, and could not reasonably have guessed. A court's independence is not a property of the court. It is a property of how the judges get their jobs, and over the next 76 years, the way Hawaii's judges got their jobs was going to change completely, 3 separate times, while her sentence stayed exactly as she wrote it. One more thing before we follow it forward, because there is a legal fact underneath this whole story that most people have never had explained, and that makes everything else make sense. Why is this thing still here? Ordinary private wealth does not survive like this. Family fortunes get divided among heirs, spent, taxed on death, litigated over and dissipated. The old rule of thumb is 3 generations from shirt sleeves to shirt sleeves, and it is a rule of thumb because it is usually roughly right. Charitable trusts are different, and the difference is deliberate, and it is ancient. The common law has a doctrine called the rule against perpetuities, which exists to stop dead people controlling property forever. In its classical form, it says that a private interest in property must vest, if at all, within 21 years of the death of somebody alive when the arrangement was created. Generations of law students have been tortured by it. The purpose is simple: a society in which the wishes of the long dead permanently determine who gets what is, a society that cannot function. Charitable trusts are exempt from that rule. They always have been. A trust for a charitable purpose, recognised as such, may last forever. There is no expiry. There is no point at which the founder's instructions lapse, and the property becomes freely disposable. The reasoning is that a private perpetuity locks wealth away from the living for the benefit of one family, while a charitable perpetuity locks it away for the benefit of the public, and the public is always there to benefit. Layer onto that the second privilege, which is tax. A recognised charitable trust does not pay income tax on its investment returns, which means that compounding, the most powerful force in finance, operates on the whole return rather than on the after-tax return, year after year, without limit. Put those two together and you get an object that essentially does not exist elsewhere in the economy. A pool of assets that cannot be broken up, cannot be inherited, cannot be taxed on its earnings, and has an infinite time horizon. Over 140 years, that produces the numbers in this story. It is also, incidentally, why the IRS threat in 1999 was so overwhelming. The exemption is not a discount. It is the entire physics of the institution, and it is why the supervision question is not a technicality. A body with those privileges has no shareholders, no customers who can leave, no voters and no owners. The only external check on it is a court, an attorney general, and whatever the founding document happens to say, which is why the founding document matters so much, and why one sentence in it can be worth $10 billion. Now, the schools got built, and that part went well. Charles Reed Bishop outlived his wife by 31 years, and spent a great deal of that time making her will real. He was one of the 5 trustees and the only one who had actually known what she wanted from the inside. The Kamehameha School for Boys opened in 1887, 3 years after her death, on a site in Honolulu. The first graduating class was 14 boys. A preparatory department for younger children followed in 1888. The Kamehameha School for Girls opened in 1894. And in 1889, Charles Bishop founded something else in her name. He built a museum to house the Hawaiian and royal collections that had come to Pauahi through her inheritances, including artifacts from the royal families that had converged into her hands along with the land. He called it the Bernice Pauahi Bishop Museum, and it is today the largest museum in Hawaii and one of the most important collections of Pacific material anywhere on Earth. There is something worth saying about Charles Reed Bishop because he is the easiest person in this story to overlook, and he is unusual. He was a foreigner who married into the Hawaiian ruling family, and then, when his wife died, leaving an estate larger than his own, spent the remaining 3 decades of his life executing her instructions rather than his. He was one of the 5 original trustees, and he served for years. He funded the schools out of his own money on top of what the trust provided. He founded the museum in her name and endowed it. He gave to Hawaiian causes continuously. He also did something that almost nobody in his position does, which is that he left. After the overthrow, he moved to San Francisco permanently and kept sending money for the next 20 years without living anywhere near the things he was funding. His own trust, the Charles Reed Bishop Trust, still operates today. He's buried beside his wife at Mauna Ala in the Kamehameha tomb, which is to say in the royal mausoleum of a kingdom he was not born into and which no longer exists. Bishop eventually left Hawaii. After the overthrow of the monarchy, he moved to San Francisco, and he never came back, and he died there in 1915 at the age of 93. He continued to give money to the schools for the rest of his life. So the founding worked. The institution existed. Children were being educated. Now the other thing that happened while that was going on, look again at the 5 men Power he named as her first trustees: Charles Bishop, Samuel Damon, Charles Hyde, Charles Cook, William O. Smith. 4 of the 5 were Americans or the sons of American missionaries. That was not unusual in the Honolulu of 1883. The missionary families and their descendants had by then become the commercial class of the kingdom, and they ran the banks, the sugar agencies and the newspapers. On the 17th of January 1893, a group of men in Honolulu, most of them from exactly that class, backed by a company of United States Marines landed from a warship in the harbour, deposed Queen Liliuokalani and declared a provisional government. William O. Smith, the 5th trustee named in Bernice Pauahi Bishop's will, was one of the men involved. He served the provisional government and then the republic that followed it, and he held office as Attorney General. Samuel Damon, another of the 5, became Minister of Finance under the provisional government. So the Queen, who appears in Clause 4th of Pauahi's will, receiving 2 land divisions for the term of her natural life as a token of goodwill, was removed from her throne by men who appear in Clause 14th of the same document as its trustees. That is not a coincidence, and it is not a conspiracy. It is a description of how small the governing class of Honolulu was. There were only so many people in the room, and they were in all the rooms. But it establishes something about the trust from the beginning that is worth being honest about. The institution created to preserve the future of Hawaiian children was, in its first decades, administered largely by the same faction that had just dismantled the Hawaiian government. It is worth putting the overthrow itself on the record properly, both because this trust exists inside it, and because the American telling of it was wrong for a very long time. Liliuokalani had come to the throne in 1891 on the death of her brother Kalakaua. Kalakaua's reign had been effectively neutered 4 years earlier by what is remembered as the Bayonet Constitution of 1887, a document forced on him under armed threat by a group of largely American and European residents, which stripped the monarch of most executive power and rewrote the franchise so that wealthy foreign residents could vote, while most Hawaiians and all Asian residents could not. Liliuokalani intended to replace it with a constitution restoring authority to the throne and the vote to Hawaiians. On the 14th of January 1893 she moved to promulgate it. 3 days later, a group calling itself the Committee of Safety, 13 men, most of them American or of American descent, and several of them the sons of missionaries, declared a provisional government. The United States Minister in Honolulu, John Stevens, ordered the landing of a company of Marines from the USS Boston, ostensibly to protect American lives and property. They took up positions near the palace. The Queen did not fight. She yielded in a written protest explicitly under duress, and stated that she yielded to the superior force of the United States of America, and that she did so until such time as the government of the United States should undo the action of its representative and reinstate her. That did not happen. President Cleveland sent a commissioner named James Blount to investigate, and the resulting Blount report concluded that the overthrow had been illegal, and that the American minister had acted improperly. Cleveland called for the Queen's restoration. Congress declined to act on it. The provisional government became the Republic of Hawaii in 1894. In 1895 there was an attempted counter-revolution. It failed, and Liliuokalani was arrested, tried, and confined for months in a room in her own palace. 100 years later, in 1993, the United States Congress passed, and President Clinton signed what is known as the Apology Resolution, formally acknowledging that the overthrow was illegal, that it occurred with the participation of agents of the United States, and that the native Hawaiian people had never directly relinquished their claims to their inherent sovereignty. That resolution is a statement of fact and regret rather than a transfer of anything, and the question of what follows from it has been argued ever since. But it is the context in which every sentence about Hawaiian land has to be read, including the ones in this will. The Republic of Hawaii lasted 4 years. In 1898, the United States annexed the islands. In 1900, they became a territory of the United States. And now, watch what happens to the sentence. Pauahi's will directs that trustee vacancies be filled by a majority of the justices of the Supreme Court. In 1883, That meant the Supreme Court of the Kingdom of Hawaii, whose justices were appointed by the monarch. After 1900, it meant the Supreme Court of the Territory of Hawaii, whose justices were appointed by the President of the United States. Read that again. Because of a sentence in a private will written by a Hawaiian princess in 1883, the composition of the board controlling 1 acre in 9 of Hawaii was now, indirectly, in the gift of a president in Washington. Nobody intended that. Nobody voted on it. The words did not change. The meaning of the words changed because the institution the words pointed at had been replaced. That is the first regime change, and it happened without a single amendment to the document. Then, in 1959, Hawaii became a state. Under the state constitution, the justices of the Hawaii Supreme Court were appointed by the governor of Hawaii and confirmed by the state senate, which means the sentence now read, in practical effect, like this. The trustees of the largest private landowner in Hawaii, controlling assets that would eventually be measured in billions, would be chosen by 5 people who owed their own appointments to the governor and to the state senate. The clause had gone from pointing at the least political body in the country to pointing at a body whose members were selected by the 2 most political offices in the state, and nobody rewrote it because it was not obviously broken. For a long time it was not broken at all. It took decades for anyone to work out what could be done with it, and the reason it took decades is the next part of this story, which is that for most of its history, the Bishop estate was not worth capturing. Because for about 70 years the richest landowner in Hawaii was broke. This sounds impossible, and it is not. It is the oldest problem in landholding. Land is not money. Land is a thing that produces money if somebody does something productive with it, and if nobody does, it is a thing you pay taxes on. Most of what power he left was not Waikiki. Most of it was mountain, forest, lava field, pasture and watershed on 5 islands, conservation land and agricultural land, beautiful, and in the 19th century economy, close to worthless per acre. And the trust could not simply sell it and invest the proceeds, because that was not the point. The land was the corpus. Selling the corpus to fund operations is how a trust eats itself. So the trustees did the obvious thing, which was to lease. They leased pasture to ranchers. They leased flat land to the sugar plantations, which by the late 19th century were the engine of the Hawaiian economy. And later, as Honolulu grew, they leased residential lots to families who wanted to build houses. That last one is the important one, and it needs explaining. Because the residential leasehold system is unfamiliar to most people, and it shaped modern Hawaii. In most of the United States, when you buy a house, you buy the house and the ground under it. In Hawaii, for most of the 20th century, an enormous share of residential property was sold leasehold. You bought the house. You did not buy the land. You paid ground rent to the landowner on a long lease, typically 55 years or so, and at the end of the lease the land and everything standing on it reverted to the owner. The reason that system existed is that a small number of large landowners held most of the developable ground and did not want to part with it permanently. The largest of them was the Bishop estate. For the trust, it was ideal. The corpus stayed intact in accordance with the will, and it threw off a steady income stream. For the family living in the house, it was considerably less ideal. You could spend 30 years paying off a mortgage on a building that sat on ground you would never own. Watch your ground rent get renegotiated upward, and know that at some point the whole thing reverted to a charitable trust. And the political consequences of that arrangement built up slowly, and then all at once. Picture a family in Honolulu in the 1950s buying a house on Bishop estate land. The lease has 55 years to run, which at that point feels like forever, and the ground rent is a modest fixed sum. They raise children in it. Now move forward 30 years. The children have children. Honolulu has become one of the most expensive property markets in the United States, and the lease reaches its first rent renegotiation date, at which point the ground rent is reset to reflect current land values rather than 1950s land values. For a great many families, the new figure was a multiple of the old one, and for some it was unpayable. People who had spent decades paying off a mortgage discovered that the ground beneath the house they owned had become more expensive than the house, and behind that, the harder arithmetic. When the lease finally expired, the land reverted, and so did everything built on it. The house you paid for became the landowner's house. None of this was a trick. It was written into the lease and everybody had signed it. But a legal arrangement that looks reasonable at signature can become socially unbearable at scale. And by the 1960s, this one had. because a very large share of the housing on Oahu sat on leasehold ground and a very small number of owners held the fee. That is the pressure that produced the Land Reform Act, and it repays a moment understanding that the pressure came from ordinary homeowners rather than from ideologues. The politics of leasehold conversion in Hawaii was not abstract. It was thousands of families who wanted to own the dirt under their own kitchens. Even so, the income was modest for a very long time. Through the first half of the 20th century, the trust was described accurately as land rich and cash poor. It generated enough to run the schools and not a great deal more, which is why, for 70 years, nobody thought of a bishop estate trusteeship as a prize. It was a civic duty. It was unpaid or nearly so. It was the kind of thing a retired banker did. Then two things happened, about 20 years apart, and together they turned a quiet land-holding charity into the largest concentration of private wealth in the state. The first was the Supreme Court of the United States. By the 1960s, the leasehold system had become politically intolerable in Hawaii. The state legislature ran the numbers and found something startling. The state and federal governments between them owned nearly 49% of the land in Hawaii. Another 47% was owned by 72 private landowners, which means that in a state of roughly 750,000 people at the time, about 96% of the ground was controlled by 2 governments and 72 entities. The legislature described this as a land oligopoly and concluded that it was inflating prices and injuring the public, and in 1967 it passed the Land Reform Act. What the act did was remarkable. It allowed the state to use eminent domain, the power of compulsory purchase, to condemn residential land and then to sell it to the very people who were already leasing it. Not to build a road, not for a school or a reservoir. To take land from one private owner and transfer it to another private owner, on the theory that breaking up a concentration of ownership was itself a public purpose. That is constitutionally aggressive, and the landowners said so. A group of them sued, arguing that the act violated the Takings Clause of the Fifth Amendment, which permits government to take private property for public use with just compensation, and which they argued does not permit taking property from one private party to hand to another. The lead named plaintiff was Frank Midkiff. Frank Midkiff was a trustee of the Bishop Estate. The case went up. The federal district court sided with the state. The Ninth Circuit reversed and held the condemnation provisions unconstitutional, and on the 30th of May 1984, the Supreme Court of the United States decided Hawaii Housing Authority against Midkiff. The vote was 8-0. Justice Sandra Day O'Connor wrote for the court. Justice Marshall took no part. The state won completely. The court held that the public use requirement is coterminous with a state's police powers, that the legislature's judgment about what serves a public purpose is entitled to great deference, and that redistributing concentrated land ownership to correct the effects of an oligopoly is a legitimate public purpose. It is one of the most important eminent domain cases in American law, and 21 years later it would be the principal precedent relied on in Kelo against New London, the case that made this whole doctrine notorious across the country. But the part that matters, the practical effect on one landowner. Over the following years, lessees on Bishop Estate land could and did force the sale of the ground under their houses. The trust had to convert land into cash, in volume, whether it wanted to or not. Understand what that does to an institution. For a century, the Bishop Estate had been an organisation that held things. Its job was custody. Its income was rent. Its decisions were about leases and land use, and its trustees needed to understand agriculture, zoning and the long game. After Midkiff, it became an organisation that had money. Large amounts of money, arriving from forced sales, that had to be put somewhere, and that could be put almost anywhere in the world. The skill set changed. The scale changed. And crucially, the discretion changed. A trustee deciding whether to renew a pasture lease has limited room to do damage. A trustee deciding where to place hundreds of millions of dollars has a great deal. The Land Reform Act was passed to break up a land oligopoly, and it did. It also, without anyone intending it, converted the Bishop Estate from a landlord into an investment fund. That is the first of the two things. The second thing had happened 13 years earlier, in 1971, and at the time it looked like a fight about a name. A vacancy came up on the board. Under Clause 14th, the justices of the Hawaii Supreme Court were to fill it. They chose Matsuo Takabuki. Takabuki was a Honolulu lawyer and a former city councilman. He was a veteran of the 442nd Regimental Combat Team, the celebrated Japanese-American unit of the Second World War, and he was a close political associate of John A. Burns, the governor of Hawaii, and one of the central figures in the Democratic coalition that had taken control of the state in the late 1950s and would run it for decades. He was also not Hawaiian. The reaction was immediate and it was furious. Native Hawaiians protested the appointment publicly. The charge was straightforward and it was made openly. This was a political payoff. The Democratic machine had placed one of its own on the board of the largest Hawaiian estate in existence, and the justices who made the appointment were themselves appointees of that machine. That is the moment. That is where the sentence gets used, for the first time in a way that is publicly visible, as an instrument of state politics. And now, the complication, which I am not going to skip, because skipping it would make this story simpler than it is and considerably less true. Matsuo Takabuki was a very good trustee. He served for more than 20 years. In that time, the trust went from a land-rich, cash-poor charity that barely covered the expenses of the schools to a multi-billion-dollar institution with holdings on 3 continents. He is the single person most responsible for the modern Bishop Estate portfolio. By the time he retired, he was regarded with real affection by many of the people who had protested his appointment. Myron Thompson, a native Hawaiian who served as a trustee himself, said of him that he was as Hawaiian as anyone around here. And privately, when the trust started cutting outreach programs for Hawaiian children in the mid-90s, including preschool classes for poor families, Takabuki was reported to be disappointed by it. So the first clearly political appointment under Clause 14th produced an excellent trustee, which is exactly why the flaw took another 25 years to become undeniable. A mechanism that produces a good result is very hard to argue against. Nobody dismantles a door because a good person came through it. The trouble with a door is that it does not know who is using it. To see how the door came to be used, you have to understand the shape of Hawaii politics in the second half of the 20th century, and it can be stated fairly briefly. From 1954 onward, the Democratic Party dominated Hawaii to a degree that has few parallels in any American state. It controlled the legislature more or less continuously. It held the governorship for almost all of that period. It was not a machine in the crude sense of the word, and it grew out of a genuine and important movement, the post-war assertion of the island's Asian American and working class communities against a commercial elite that had run the place since the plantation era. But it was durable, and durability changes things. When one party holds every lever for 40 years, the meaningful political contests stop happening between parties and start happening inside one. Now overlay Clause 14th on that. Justices of the Hawaii Supreme Court are nominated by the governor and confirmed by the state senate. Both of those are Democratic offices for essentially the entire period in question. Those justices, acting under a sentence in an 1883 will, choose the trustees of the Bishop Estate, and a Bishop Estate trusteeship by the 1980s was a position of extraordinary power and, as we will get to, extraordinary pay. Follow the loop around. The Senate confirms the justices appoint the trustees, and the people best placed to become trustees are the people the Senate knows, which is to say, the people in the Senate. Look at who actually got appointed. Richard Wong, known universally as Dickie Wong, had been the president of the Hawaii State Senate. He became a Bishop Estate trustee in 1993. Henry Peters had been the Speaker of the Hawaii House of Representatives. He became a trustee too. And William S. Richardson, who had served as Chief Justice of the Hawaii Supreme Court, and who in that capacity had participated in appointing Bishop Estate trustees, later became a Bishop Estate trustee himself. Put those 3 facts next to each other and the circuit is complete. The presiding officer of the Senate, the presiding officer of the House, and a former Chief Justice, all sitting on the board of a charitable trust for the education of Hawaiian children, appointed by a court whose members were confirmed by the body 2 of them had led. And it is worth understanding what filling a vacancy actually looked like in practice, because the word appointment makes it sound like an event and it was closer to a season. A trusteeship came open perhaps every few years. There was no advertisement, no published set of qualifications, no application, and no requirement that the justices explain their reasoning afterwards. The will simply said that a majority of them would choose, so the process, such as it was, ran on private conversation. Names circulated. People let it be known that they were interested. Others let it be known, on their behalf, that they should be considered. Letters arrived, calls were made. The 5 people making the decision were individually appointees of a governor and confirmees of a state senate, and would remain in a professional world in which the goodwill of both mattered for the rest of their careers. None of that is corruption in the criminal sense, and none of it requires anybody to be bribed. It only requires that a small number of people with discretion, no obligation to explain themselves, and ongoing relationships with the political apparatus be asked repeatedly to do a favour that costs them nothing. That is the whole machine. It is not dramatic, and it does not need to be. Randall Roth, a professor of trust law at the University of Hawaii who's going to matter a great deal shortly, described the resulting environment in terms that are worth quoting exactly. There was a price to pay, he said. The trustees themselves were known as being very vindictive. You didn't want to cross them, but they had their tentacles in the executive branch, the legislative branch, and the judicial branch, and an awful lot of people who were in a position to see that things were not right, for whatever reason, chose not to cross these powerful people. That is the atmosphere. Now the money. In 1992, Matsuo Takabuki, in the last stretch of his tenure, made the investment that changed the scale of everything. Goldman Sachs at that time was a private partnership. It was not a public company. Ordinary investors could not buy a share of it at any price, because there were no shares. The firm was owned by its partners. But Goldman wanted outside capital, and in 1992 it went looking for it. And Bishop Estate wrote a check for $250 million in exchange for just over 9% of the firm. Read that again. A charitable trust founded by a Hawaiian princess to educate orphans and indigent children, operating out of an office in Honolulu, owned 9% of Goldman Sachs. 2 years later, John Corzine, who by then was running the firm, came back and asked for another $250 million. The reason he came back is not a happy one. Goldman was having a bad stretch. Partners were quitting and taking their capital out with them, which had never happened before, and there was a real possibility when Bishop Estate agreed to double down that the firm would come apart. By then Takabuki had retired. The trustee running asset management was Henry Peters, and Peters put himself in charge of the negotiation. Goldman did not come apart. The global economy boomed, and on the day Goldman Sachs went public in 1999, the trust's $500 million position was worth roughly $1.5 billion before tax. That is the moment the Bishop Estate becomes, by most reckonings, the wealthiest charitable trust in the United States, wealthier than any American university endowment of the era. Estimates of the whole corpus in the late 90s ran to $10 billion and above. Goldman Sachs was the headline, but it was not the whole portfolio, and the rest of it explains why the trust's affairs became so hard for anyone outside to follow. Through the 80s and 90s, the estate moved a long way from Hawaiian land. It took positions in mainland real estate, in commercial developments on the West Coast and in the American Southwest. It invested abroad, with holdings described at the time as spanning 3 continents. It went into private equity, venture deals, and a range of operating businesses. Some of that was straightforwardly good stewardship. A trust with a perpetual horizon that holds one asset class in one place is badly exposed, and diversifying out of Hawaiian dirt was defensible and probably necessary after Midkiff forced so much of it into cash. But it had 2 effects that mattered enormously. The first is opacity. A trust that owns pasture on Molokai can be understood by anybody who can read a lease. A trust that holds interests in dozens of private ventures across 3 continents cannot be understood by anybody except the people running it, and the people checking their work have to be capable of the same analysis. The court-appointed masters reviewing the accounts were Honolulu attorneys, not investment analysts. It is not a criticism of them to say that reviewing 47 private investments spread over 3 continents is not a job for one lawyer and an afternoon. It took a full investigation with a major accounting firm attached to produce the list. The second effect is that discretion expands with complexity. When there are 1,000 plausible places to put money, a decision to put it in one of them rather than another is very difficult to challenge from outside because there is no obvious benchmark for what should have happened instead. That is the environment in which questions about who was benefiting from which transaction became almost impossible for an outsider to answer, and it is why the eventual investigation needed subpoena power to get anywhere. And this is where you should start paying close attention to the numbers being reported by the trustees themselves, because they do not match. As late as the beginning of 1998, the trustees were reporting the fair market value of the trust's assets at about $2 billion. At the same time, the assessed value of estate land on the island of Oahu alone was approaching $5 billion. And the Goldman Sachs stake by itself was generally thought to be worth as much as $3 billion. So the trustees' own stated figure for everything was smaller than either of two individual components of it. Critics at the time drew a straight line from that understatement to a specific argument the trustees were making. If the trust is worth $2 billion, then spending about $70 million a year on the schools looks like a reasonable, even generous distribution rate. If the trust is worth $10 billion, $70 million a year looks like something else entirely. Now go back and read Pauai's transparency clause again, the one she wrote in by hand when nothing in the law required it. A full and complete report of all receipts and expenditures, an inventory of the property in their hands and how invested, filed annually with the Chief Justice and published in a newspaper in Honolulu. 115 years later, the accounting was such that the trust's own valuation of itself was off by a factor of 5, and the person it was legally supposed to be filed with was the head of the court that had appointed the people filing it. Then the question is this of what the trustees were paid. The answer is approximately $1 million a year, each, 5 of them. That made the trustees of the Bishop Estate the highest paid charity employees in the United States of America. The justification was technical, and it was not invented on the spot. An old provision of Hawaii law allowed trustees to take commissions calculated as a percentage of the income and receipts they handled. Applied to a portfolio of that size, the formula produced numbers that nobody drafting it in the 19th century had ever contemplated. So the trustees could and did say that they were simply taking what the statute permitted. They also pointed out correctly that managing a multi-billion-dollar portfolio with global holdings is demanding work, and that comparable work in the private sector pays more. Both of those things are arguable. What is harder to argue is the comparison that sat in plain view. 5 people were being paid roughly $5 million a year in total, out of a trust that was distributing about $70 million a year to the schools those 5 people existed to run. For every $14 reaching the children, $1 was going to the board. And the schools, meanwhile, had begun to feel the presence of the board in a way they never had before. This is the part of the story that turned public opinion, and it is not about money at all. Sometime in the early 1990s, the trustees adopted a governance structure they called the lead trustee system. Instead of 5 trustees making decisions collectively as a board, each trustee was assigned a domain and given operational authority over it. 1 trustee led asset management, 1 led education, and so on. If you know anything about how boards are supposed to work, that should sound alarming immediately, because it dissolves the thing a board is for. A board's value is that no individual acts alone. 5 people who each run their own kingdom are not a board. They are 5 executives who happen to share a letterhead. The court-appointed master reviewing the trust's accounts, a Honolulu attorney named Colbert Matsumoto, said as much in his report for the 1993 to 1994 fiscal year. He faulted the lead trustee system directly and said it may violate the terms of Bernice Pauai Bishop's will, which it plainly might. The will says that a majority of the trustees may act, and that 3 of them at least must join in all acts. That is not compatible with 1 trustee running a division. Nothing happened. The lead trustee for education was Lokalani Lindsay. Lindsay had been an educator and an administrator on Maui before her appointment, and what happened at Kamehameha schools after she took control of education is documented in several independent investigations, and it is one of the strangest institutional collapses in American education. The schools had a president, Michael Chun. He was a Kamehameha graduate himself, held a doctorate in engineering, and was by all accounts widely respected and widely loved by students and staff. Lindsay, as lead trustee for education, progressively took over his authority. Duties that belonged to the president were reassigned. A vice president hired in 1995, Rokna Fritas, was given functions that had been Chun's. She involved herself in the details of the school in a way no trustee had ever done. Curriculum, personnel, individual teachers, what was on the walls, and the atmosphere changed. 5 senior educators would later write in a public essay that as educators they were appalled by developments at Kamehameha schools since Lindsay's appointment as lead trustee for education, and that what had been a climate of mutual respect and trust had become one of fear and intimidation. And it was happening while the trust was cutting the programs that reached furthest down. In 1995, the trustees eliminated a set of outreach programs for native Hawaiian children. Among them were preschool classes for children from poor families. The stated reasoning was that the programs were not cost-effective and that the money was better used elsewhere. That is a defensible thing for a board to conclude about any given program, and boards conclude it all the time. What made it land badly is what it was set against. This was a trust whose annual educational spending was around $70 million, whose stake in a single investment bank was thought to be worth up to $3 billion, and whose 5 trustees were being paid roughly $1 million a year each. And the specific instruction in the will, in Pauahi's own words, is to devote a portion of each year's income to the support and education of orphans and others in indigent circumstances. Preschool for poor Hawaiian families is not adjacent to that sentence, it is that sentence. Even Matsuo Takabuki, the trustee whose appointment in 1971 had been protested as a political payoff and who had spent 20 years building the portfolio that generated the money, was privately reported to be disappointed by those cuts. Michael Chun, meanwhile, remained in place through all of it. He did not resign, he did not go public, and he stayed at the school through the entire period in which his authority was being dismantled around him. When the interim board took over, he was still there. He would go on to serve as head of the Kapalama campus until 2012, having led it for 24 years. Teachers began keeping records. Alumni started talking to each other. Something was forming inside the school that had no name yet. Meanwhile, in the boardroom, one man had been trying to raise the alarm for years and getting nowhere. Oswald Stender, known as Oz, had been appointed a trustee in 1989. He came out of real estate management, he was native Hawaiian, and he was, from fairly early on, the odd man out. Stender had concerns about the conduct of his colleagues. He raised them privately, repeatedly. He shared them with a series of court-appointed masters, and in 1992, and again in 1995, he went to lawyers at the Attorney General's Office of the State of Hawaii, which under long-standing law is the office responsible for supervising charitable trusts on behalf of their beneficiaries. He tried, twice, over 3 years, to get the state's chief legal officer to open an investigation into the largest charitable trust in the country. Nothing happened either time, and it is worth being clear-eyed about Stender's own position, because the story that gets told afterwards makes him a hero, and the reality is more complicated. He was in that boardroom for years. He voted on things. When investigators eventually started listing the trust's problems, a great many of the allegations applied to the whole board, and Stender had been in the room longer than anyone except Henry Peters. His personal exposure was substantial. He was, in other words, a man with real information, real objections, and a real reason to be careful. Dickie Wong, who chaired the board, had a formula for how the room worked that he repeated to people often enough that it became known. 5 beats 4, he would say. 3 beats 2, 2 beats 1. For years, Stender was the one. Then, in the spring of 1997, the arithmetic in that room stopped being the only arithmetic that mattered, and the reason was that several thousand people walked out of a cemetery and down a hill. The cemetery is called Mauna Ala, the Royal Mausoleum of Hawaii, in Nuuanu Valley above Honolulu. It is one of the few places in the islands that never became American. When the monarchy was overthrown and the flag came down, Mauna Ala remained. It holds the remains of most of the Kamehameha and Kalakaua lines, and it is the only site in the state where the Hawaiian flag flies alone, and is never lowered to half-mast because it is treated as sovereign ground. Bernice Pauahi Bishop is buried there, in the Kamehameha tomb next to her husband. On the 15th of May 1997, several thousand people gathered outside that mausoleum. Teachers from Kamehameha schools, alumni, some of them elderly wearing their class colours, parents, students, staff from the estate itself, and they walked out of the gate and down through Honolulu to the headquarters of the Bishop Estate at Kawaiahau Plaza to protest against the conduct of the trustees who had been appointed to look after what the woman in that tomb had left. The distance is about 2 miles. The symbolism does not require explanation. They started at her grave. That march is the hinge of this entire story, and it repays a moment to ask why it worked when nothing else had. For years, the problem had been that everybody who knew something had a reason to keep quiet. Employees could be fired. Lawyers had firms that needed state work. Politicians needed the machine. Journalists needed access. Stender had gone to the Attorney General twice and been ignored. Court-appointed masters had filed critical reports that produced no consequence at all. Every individual channel was blocked, because every individual channel ran through a person who could be reached. A crowd cannot be reached. There is nobody to call. The teachers had organized under a name, Nakumu o Kamehameha, the teachers of Kamehameha, and what they had done was to make the private grievance a public fact. Once several thousand people had walked down that hill in front of the newspapers and the television cameras, the thing everybody knew and nobody said became a thing that had been said, out loud, by a lot of people at once. It is worth being precise about how that march came together, because it did not happen by itself, and the people who built it took a real risk. Teachers at Kamehameha schools were employees of the Trust. The Trust could fire them. In a small state with one elite private school and a limited number of teaching posts, being known as a troublemaker at Kamehameha was not a small professional problem they organised anyway, under the name Nakumu o Kamehameha, the teachers of Kamehameha. What began as a grievance about how the school was being run turned into something closer to a labour organisation, and then into a public campaign. Alumni were the second leg of it, and alumni are much harder to punish. Kamehameha graduates are spread through every profession in Hawaii. They have class associations that meet regularly, and they have an attachment to the institution that is difficult to overstate, because for many of them it was the thing that changed the shape of their lives. Once the teachers and the alumni were talking to each other, the Trust had a problem it could not manage by managing individuals, and the people who were seen at those alumni meetings in the run-up were noticed. Being visible in that organising effort put people on lists inside the institution. That was understood at the time, and they did it anyway. That changed what was possible for the small number of people who had been trying to decide whether to speak. If you are still with me this far into a story about one sentence in an 1883 will, you are exactly who this channel is for, and subscribing keeps the long ones coming. Because 3 months after that march, 5 people put their names to something that ended the whole arrangement. On Saturday the 9th of August 1997, the Honolulu Star-Bulletin published an essay in its editorial section, under a banner headline across the top of the page, Broken Trust. It was about 6,400 words long, which is to say it ran to roughly the entire section. Newspapers do not do that. A guest essay of that length in a daily paper is not an opinion piece. It is an event. It opened like this. The community has lost faith in Bishop Estate trustees, in how they are chosen, how much they are paid, how they govern. The time has come to say no more. And then it went through, in detail, the whole architecture. That the trustees were underqualified for the work they were doing. That they were grossly overpaid. That they had been selected through a rigged political process. That their financial management was loose and self-serving. And that their most distinguishing characteristic as a board was conflicts of interest. The reason the essay detonated is not primarily what it said. Versions of most of it had been circulating in Honolulu for years. The reason it detonated is who signed it. There were 5 authors, and 4 of them were kupuna, Hawaiian elders, people whose standing in the community made them nearly impossible to attack. Samuel P. King was a judge of the United States District Court for the District of Hawaii. He was the son of a territorial governor of Hawaii, and he was part Hawaiian himself. He had been on the federal bench since 1972. This was not a man who could be dismissed as a crank or a partisan, and he was, notably, a judge publicly criticising the conduct of the state's judiciary. Monsignor Charles Kekumano was a Roman Catholic priest, a Hawaiian, and himself a trustee of another major Hawaiian charitable estate, the Queen Liliuokalani Trust. He knew from the inside how a trust of this kind was supposed to be run. Walter Heen was a retired judge of the Hawaii Intermediate Court of Appeals and a former legislator and part Hawaiian. Gladys Brandt was one of the most revered educators in the islands. She was a Kamehameha Schools graduate. She had been principal of the Kamehameha School for Girls, and she had spent a lifetime in Hawaiian education. When Gladys Brandt said something about Kamehameha Schools, it carried a weight no institution could push back against. And the 5th author was Randall Roth, a professor at the University of Hawaii Law School whose academic specialty was, precisely and inconveniently, the law of trusts. So the essay was signed by a sitting federal judge, a retired appellate judge, a priest who ran another Hawaiian trust, the most respected Hawaiian educator alive, and the state's leading academic expert on exactly the body of law in question. There was no answer to that lineup. You could not say they did not understand trusts, because one of them taught it. You could not say they were anti-Hawaiian, because 4 of them were Hawaiian and 1 had run the school. You could not say they were opportunists, because none of them had anything to gain, and several had a great deal to lose, and it very nearly did not run. Honolulu in 1997 was a 2-newspaper town. The larger paper, the Morning Honolulu Advertiser, was offered the essay first. The Advertiser declined it. Roth then took it to the smaller afternoon paper, the Star Bulletin, which published it. Think about what that near miss means. The single most consequential piece of journalism in modern Hawaii was rejected by the state's biggest newspaper, and it survived because there happened to be a second one. The essay made one argument that is worth isolating, because it goes to the heart of Clause 14th. For years, the justices of the Hawaii Supreme Court had defended their role in selecting trustees on a specific technical ground. When they picked trustees, they said, they were not acting as a court. They were acting as private individuals, exercising a power given to them by name in a private document. The court as an institution was not involved, and then, having selected those trustees as private citizens, the same justices would put on their robes and, as a court, decide cases involving the very same trustees. The authors of Broken Trust said that this would not do. Private citizens are always free to decline. But once you agree to select the trustees of a charitable trust, you have taken on a duty, and that duty is to make a good faith effort to select trustees who will actually further the trust's charitable purpose. You cannot take the power and disclaim the responsibility. That argument is the reason this story is not simply about 5 people behaving badly. Because if the justices were right, then Pauhi's safeguard had no supervisor at all. The trustees were watched by the court. The court's selection of the trustees was watched by nobody, on the grounds that it was not really the court doing it. There was a hole in the middle of the machine, and the hole had been there since 1883, and nobody had needed to look at it until the thing inside the machine was worth $10 billion. Within days of publication, the thing that had been impossible for 15 years became unstoppable in about a month. 3 investigations were now running at once, and only 2 of them were public. The first was the state's. Marjorie Bronster was the Attorney General of Hawaii, appointed by Governor Benjamin Caetano. She was a New Yorker by origin, a graduate of Columbia Law School, and she had come to the office from private practice rather than from the political apparatus, which turns out to matter. It has to be said that the Attorney General's office had not covered itself in glory up to this point. Under the doctrine of parens patriae, literally parent of the country, the Attorney General is the officer legally charged with protecting the beneficiaries of charitable trusts, who are usually children or the public at large and cannot sue on their own behalf. That office had been approached by a sitting trustee twice, in 1992 and 1995, and had not acted. It had not acted when the Master's reports were critical. It had not acted when several thousand people marched down from the Royal Mausoleum. After the 9th of August, it acted. Bronster opened a full investigation into the conduct of the trustees, and she convened a grand jury, and over the following year her office worked through the trust's transactions. The second investigation was the trust's own, and it happened because the probate court ordered it. Colbert Matsumoto, the same attorney who had criticised the lead trustee system years earlier as a court-appointed master, was brought back to run a full internal review. He worked with another attorney, Bob Zakamaki, and with accountants from Arthur Anderson. Their work eventually produced a list of 47 Bishop estate investments that required scrutiny. It is worth being concrete about what the allegations actually were, because the phrase breach of fiduciary duty is doing a lot of work, and it does not convey much on its own. A fiduciary is somebody who holds power over another person's property, and is legally required to exercise it solely in that person's interest. It is the strictest standard the law imposes on anybody. A fiduciary is not merely forbidden to steal. A fiduciary is forbidden to put themselves in a position where their own interest could conflict with the beneficiaries, regardless of whether they actually take advantage of it. The allegations against the trustees fell into 3 broad categories. The first was self-dealing in investments. The charge was that trust funds had been placed into ventures in which trustees held personal stakes, and the business had been directed to associates and to firms with connections to the board. The second was the use of the trust's position as a landowner for personal benefit. One allegation that received a great deal of attention was that trustees had accepted free memberships at a golf course whose land lease, held from the estate, was up for renegotiation. Think about the structure of that even without knowing whether the renegotiation was effected. The person deciding what rent a tenant will pay is receiving something valuable from that tenant. Under fiduciary law, it does not matter whether it changed the outcome. Being in that position is the violation. The third was the use of estate staff and resources for trustees' personal business, and running under all of it was the largest allegation of all, which is the one the Attorney General put in her removal petition, that the trustees had withheld something in the region of $350 million in trust income from the Kamehameha schools. Not stolen, withheld, retained inside the trust rather than distributed to the purpose the trust exists for. That allegation is, in a way, the most serious one in the file, because it does not require anybody to have pocketed anything. It goes to the question of what the whole institution was for, and it connects directly back to the disputed valuation. A board that reports the trust at $2 billion can defend a $70 million distribution. A board that reports it accurately cannot. There was also a separate investigation, ordered by the probate court and conducted by an attorney named Patrick Yim, into what had been happening inside the schools themselves. The Yim report came out in December of 1997, and it was devastating on the subject of the education side of the house. And then, in a piece of theatre that would be hard to invent, Lokalani Lindsay leaked her own confidential report attacking the school's leadership, which had the effect of putting the whole internal conflict into the public domain in her own words. That combination changed Oswald Stender's legal position completely, and it repays explaining how, because it is a good illustration of why nothing had moved for years. Stender's problem had never been knowledge, it was exposure. Almost every allegation against the board applied to the board collectively, and he had been on it since 1989. If he moved to remove his colleagues on grounds of general mismanagement, he was arguing for his own removal at the same time. The Yim report and Lindsay's leaked document gave him something different. They gave him grounds to seek the removal of one specific trustee on the basis of one specific set of conduct in one specific domain, in which he had played no part. So Stender sued to remove Lindsay, and by then he was not alone in the room. Gerard Jervis had moved to his side, which meant the count was 2, and Wong's formula ran the other way for the first time. Stender was 1 vote from control of the Bishop estate. Now the third investigation, which almost nobody knew about. The Internal Revenue Service of the United States had been quietly examining the Bishop estate for 2 years. The reason the IRS has jurisdiction here is simple, and it is enormous. The Bishop estate was a tax-exempt charitable trust. That exemption is what allowed a $10 billion portfolio to compound without paying tax on its income, which is a subsidy of extraordinary size, and it is granted on one condition, which is that the entity is actually operated for charitable purposes and not for the private benefit of the people running it. If it is not, the exemption can be revoked, and revoking the exemption of the Bishop estate would have been a financial event of a scale that is difficult to convey. It would not have been a fine. It would have been the effective end of the institution as it existed. There was also a newer weapon available. Congress had recently passed what were called intermediate sanctions, designed for precisely this situation, which allowed the IRS to penalize individuals who took excess benefit from a charity, rather than having to destroy the charity to punish them. Legal observers at the time noted that if any case in America had been made for that statute, this was it. So by the middle of 1998, the trustees were facing the Attorney General of Hawaii, a court-ordered internal investigation with Arthur Anderson behind it, a rebellion inside their own board, a public that had marched on their headquarters, and the Federal Tax Authority. And then the last support gave way, and it gave way in the most consequential manner possible, because it was the support Pauahi herself had installed. In 1997, Chief Justice Ronald Moon of the Supreme Court of Hawaii, together with his associate justices, announced that they would no longer take part in selecting trustees of the Bishop estate. Stop and consider what that is. For 114 years, one sentence in a will had directed that vacancies be filled by a majority of the justices of the Supreme Court. It had survived a monarchy, an armed overthrow, a republic, annexation, a territorial government appointed from Washington, and statehood. It had never once been amended, and in 1997 the justices simply declined to do it anymore. They did not strike the clause, they had no power to, they withdrew. Which means the safeguard Bernice Pauaha Bishop wrote into her will to protect the trust from politics was removed, in the end, not by a court order and not by a legislature, but by the safeguard itself stepping away from the job because participating in it had become indefensible. That is the mechanism completing itself. She pointed her protection at an institution. The institution changed character, and when the consequences of that change became visible enough, the institution's only remaining option was to stop being the protection. What happened over the next 18 months is that the largest charitable trust in the United States had its entire board removed, and the person who made it happen lost her job for it. The endgame ran through the probate court. A charitable trust in Hawaii, like almost everywhere in the common law world, is supervised by a court, and the specific court here was the First Circuit Probate Court in Honolulu. Judge Kevin Chang had the file. Bronster filed to remove the trustees on the grounds that they had committed breaches of their fiduciary duties, that they had jeopardized the trust's tax-exempt status, and in an allegation that goes directly to the purpose of the whole thing, that they had withheld some $350 million in trust income from the schools. Stender's separate action to remove Lindsay went to trial, and it took 6 months. 6 months is a very long trial, and it was conducted largely in public, and what came out of it in daily installments was a portrait of how the education side of a charitable trust for Hawaiian children had actually been run. What came out of the Lindsay trial in daily installments is worth characterizing, because it is the part of this story that the Hawaiian community reacted to most strongly, and it had almost nothing to do with money. The Yim report, published the previous December, had already laid out the picture. A trustee had inserted herself into the daily operation of a school. Decisions about curriculum, about staffing, about individual teachers, and about what appeared on classroom walls had been taken by a member of a governing board rather than by educators. Teachers testified about what it had been like to work there. Administrators testified about authority being removed from the president of the schools and reassigned. The 5 senior educators who had written publicly about it had described a climate of mutual respect and trust becoming one of fear and intimidation, and the trial put detail underneath that phrase for 6 months, on the record, in front of the press. There is a reason that landed harder than the investment allegations. Most people in Hawaii could not evaluate a private equity position on the mainland. Everybody could evaluate what it means when teachers are frightened, and running underneath the litigation was the IRS, which was not interested in a trial. It wanted the trustees gone, and it had the one lever that could not be argued with. In the spring of 1999, the service made the position explicit. If the trustees remained, the tax exemption was in jeopardy. That is not a negotiation. A trust facing the loss of its exemption is a trust facing the loss of most of its value, and the beneficiaries of that loss would have been the children the trust existed for. In May of 1999, it ended. Lokalani Lindsay was permanently removed from the board following the 6-month trial. 1 day later, Richard Wong, Henry Peters, and Gerard Jervis were removed as well. Oswald Stender resigned. The entire board of the largest charitable trust in the United States was gone inside of 48 hours, 115 years after the trust was created, and an interim board was appointed by the probate court to run it. That is the headline version, and it is where most accounts of this stop. What follows is the part that is less often told, and it is the part that determines what the story actually means, because the people who fixed this paid for it, and the people who broke it mostly did not. Start with Marjorie Bronster. Hawaii's Attorney General serves at the pleasure of the governor, but must be confirmed by the state senate. Caetano reappointed her for a second term in 1999. The state senate refused to confirm her. An Attorney General of Hawaii, in the middle of the most significant charitable trust investigation in the history of the state, having just succeeded in removing the entire board of the Bishop estate, was denied a second term by the legislative body whose former presiding officer she had just helped remove. She was replaced by Earl Anzai, who had been the state budget director. Now, the Senate did not say it was about Bishop estate. Senators cited other grievances as senators do. But the sequence is what it is, and the near-universal reading in Hawaii at the time, and in every account written since, is that Marjorie Bronster lost her job because she did the job. She went into private practice in Honolulu and has had a very successful career since. That is not the point. The point is the signal that was sent to every Attorney General who would ever hold that office afterwards. Then the question is this of what happened to the trustees themselves, and here the record is surprising, and it is where a lot of retellings of this story quietly go wrong. Removal from a trusteeship is a civil matter. It is a court deciding that a fiduciary is unfit to continue. It is not a criminal conviction. and it carries no criminal penalty. Bronster's grand jury did return criminal indictments, and they were serious ones. Richard Wong was indicted for theft in the first degree, perjury, and criminal conspiracy. The allegation concerned a 1995 land transaction in East Honolulu involving the Kalalakai leasehold condominium project, which sat on Bishop Estate land. The state's case was that Wong had steered a favourable deal to a developer named Jeffrey Stone, who happened to be his brother-in-law, and that in return Stone arranged for the sale of Wong's apartment at a price $115,800 above what it was worth. The state's position was that this money belonged to the estate. Wong's wife, Mary Stone Wong, was indicted for criminal conspiracy and hindering prosecution. Jeffrey Stone was indicted for commercial bribery, criminal conspiracy, being an accomplice to theft and perjury, and in a separate indictment Henry Peters was charged with theft in the first degree and criminal conspiracy on an allegation that Stone had secured the sale of Peters' apartment for $192,500 more than it was worth. None of them was ever convicted of anything. The circuit court dismissed the indictments, the state appealed, and in 2002, in a decision reported as State against Wong, the Supreme Court of Hawaii affirmed the dismissals and then went further and remanded the case with instructions that the dismissals be entered with prejudice, meaning the charges could never be brought again. The reason had nothing to do with whether the underlying conduct had occurred. In presenting its case to the grand jury, the Attorney General's office had called Nathan Aper as a witness. Aper was the Bishop Estate's in-house lawyer, and he had been Henry Peters' attorney. The office did that without notifying Peters that his own lawyer would be testifying, without obtaining a waiver of the attorney-client privilege from him, and without getting the prior court approval that Hawaii law requires before an attorney can be called before a grand jury. The attorney-client privilege is one of the oldest protections in the common law, and courts guard it fiercely because a person who cannot speak freely to their lawyer does not really have one. Putting a defendant's own attorney in front of a grand jury without a waiver is close to the most serious thing a prosecutor can do wrong. So the case collapsed, not on the facts, which were never tested, but on the procedure. And it collapsed at the hands of the same office that had finally belatedly done the right thing by investigating in the first place. That is the outcome, and it deserves sitting with rather than skipping past. 4 trustees were removed by a court and 1 resigned. Their conduct was documented across 3 separate investigations, and in the criminal system, which is the one that produces convictions and punishments, the answer was nothing at all, permanently, because of a mistake made by the prosecution. Whatever you think happened at the Bishop Estate, the legal record contains no criminal finding against any of them, and any honest account has to say so plainly. There is one more thing about those final months, and it needs to be said carefully and then left alone. The collapse of the board was not only an institutional event. In 1999, an attorney employed by the estate, Reneo Jirikitauka, died, and trustee Gerard Jervis went through a personal crisis in the same period and did not return to the board. The circumstances were reported at the time in a way that served nobody, and this account is not going to repeat the details. They are part of the record and they belong in it, because a story about a fight over $10 billion that lists only the money has left something out. But they are not entertainment, and the people involved had families. As for what happened to the people afterwards, the honest summary is that the consequences were uneven and largely reputational. The removed trustees were removed. That is a serious professional sanction, and in a state the size of Hawaii it is a public one. But removal is not a bar on the rest of a life. Several continued in business and in public life afterwards, and with the criminal cases dismissed with prejudice, there was no legal finding standing against any of them. Richard Wong, who had been president of the Hawaii State Senate before he was a trustee, died in 2022. Obituaries in Hawaii described a truly consequential political career, alongside the way it ended, which is about the fairest thing that can be said. Oswald Stender, who resigned rather than being removed, went on to serve as a trustee of the Office of Hawaiian Affairs, elected by the voters, which is a reasonable indication of how the community read his part in it. Marjorie Bronster built a successful Honolulu law practice and has been repeatedly recognized in her field. Randall Roth and Samuel King turned the essay into a book, published in 2006, which remains the standard account and which is where most of the detail in this video ultimately comes from. King died in 2010. Gladys Brandt died in 2003, at 96, having lived to see the institution she spent her life in put back together. So, the board is gone, the interim trustees are in, and now somebody has to actually fix it. What follows is, by a considerable margin, the least famous part of this story and quite possibly the most important, because the reform of the Bishop Estate between 1999 and the middle of the 2000s is one of the more successful institutional rebuilds in American charitable law, and almost nobody outside Hawaii has heard about it. The mechanics of that rebuild are worth walking through, because they are the practical answer to the question this whole story raises. The probate court did not simply appoint 5 new people and walk away. It ran the institution under supervision. Interim trustees were appointed by the court rather than selected under Clause 14th. Court-appointed special masters were given continuing oversight of the trust's affairs, with the authority to examine its books and report back. That supervision was not a one-off audit. It became a standing feature. Colbert Matsumoto, the attorney who had criticised the lead trustee system as a master years earlier and had then run the internal investigation, ended up as an interim trustee himself, which is an unusually direct example of the person who diagnosed a problem being handed the job of fixing it. The IRS, meanwhile, did not simply go away once the trustees left. Resolving the exemption question required the trust to demonstrate, in detail and over time, that its governance had actually changed. That process shaped a great deal of what followed, because the reforms had to satisfy a federal regulator rather than merely satisfy local opinion. That is worth noticing. A significant part of why the reform was thorough is that the institution was negotiating for its life with an agency that had no stake in Hawaii politics and could not be reached through the Senate. Start with the thing that could not be fixed, which was Clause 14th itself. You cannot simply rewrite a will. The whole point of a charitable trust is that the founder's intent binds the people who come after, and courts are extremely reluctant to change the terms of a trust document, because a founder who suspects her instructions will be overridden has no reason to found anything. There is a doctrine for it, called si pres, from the Old French for as near as possible, which allows a court to modify a charitable trust when its terms have become impossible or impracticable to carry out. But it is used sparingly, and it is meant to preserve intent, not replace it. So the question after 1999 was not how to delete the sentence. It was how to give effect to what power he was trying to achieve with it, now that the body she named would no longer act. The answer, worked out over several years by the probate court, was to build a machine to do what she had asked the justices to do. Instead of 5 sitting justices choosing trustees directly, the process now runs through a screening committee. The committee is appointed under the supervision of the probate court. It advertises vacancies, solicits and evaluates candidates against defined qualifications, and forwards a slate of finalists. The court retains oversight of the appointment. Alongside that came a set of changes that would have been unthinkable in 1995. Trustee compensation was cut drastically and detached from the old percentage of receipts formula. The pay went from roughly $1 million a year to a figure in the low 6 figures, in line with what large non-profit boards elsewhere actually pay. Trustee terms were limited, so that a seat could no longer become a career. The lead trustee system was abolished. Trustees went back to being a board, with a chief executive and a professional management structure running operations. The person running the schools runs the schools. The trust's financial reporting was overhauled and opened up. Which is to say that 120 years late, somebody went back and did what Clause 13th had asked for on the day it was written. And in the year 2000, the institution changed its own name. The entity that had been Kamehameha School's Bishop Estate, and that everyone in Hawaii had simply called Bishop Estate, became Kamehameha Schools. That sounds cosmetic. It is not entirely cosmetic. Bishop Estate is the name of a landholding company. Kamehameha Schools is the name of a school. The renaming was a public statement about which of those two things the organisation understood itself to be, after a century in which the answer had drifted, and then the money started going where it was supposed to go. This is the number that makes the whole reform legible. In the mid-1990s, the trust was distributing on the order of $70 million a year to education, out of a corpus that was probably worth $10 billion. Within roughly a decade of the reform, annual educational spending had multiplied several times over. New campuses were built. The Maui campus opened in 1996 at Pukalani, on 180 acres, and the Hawaii Island campus at Kiau opened in 2001 on 300 acres, joining the 600-acre flagship at Kapalama in Honolulu. Today, the three campuses educate somewhere around 6,900 to 7,000 students, and the great majority of families pay a small fraction of the actual cost because the endowment carries it. Beyond the campuses, there are preschools, scholarship programs, community resource centres on 5 islands, and outreach programs reaching tens of thousands more children. So the institution did not merely survive, it came out substantially better at the thing it exists to do than it had been at any point in the previous 50 years. That is an unusual outcome. Most institutional scandals of this scale end in decline, sale, dissolution, or a long twilight. This one ended in a functioning school system with a $15 billion endowment, which raises a question that is worth putting directly, because the comfortable version of this story does not survive it. Did the scandal, in the end, do more good than harm? The case that it did is not trivial. Before 1997, an institution with billions of dollars was spending a small fraction of its income on children, was governed by a board that had dissolved itself into 5 personal fiefdoms and was politically untouchable. Every internal warning had failed, every legal channel had failed, every court-appointed master had been ignored. It took the near-death experience to produce the reform, nothing short of the IRS threatening the tax exemption, and a federal judge signing a newspaper essay was sufficient. The case that it did not is equally serious. Those years cost the schools enormous disruption. Programs for poor Hawaiian families were cut in the mid-90s, and children who needed them did not get them. Careers were destroyed on both sides. The Attorney General who took it on was forced out. And a community that had been given one institution out of the wreckage of a kingdom had to watch that institution be publicly humiliated. You can hold both. What you cannot do is tell it as a simple story in which the good people won, because the good people mostly paid for winning, and the bad outcome for the accused was, in criminal law, no outcome at all. Now, the present, because the thing at the centre of all this is still there, and it is still enormous. Kamehameha schools today hold somewhere between 363,000 and 365,000 acres of Hawaii. That is still, by a wide margin, the largest private landholding in the state. Depending on which total acreage figure you use for the islands, it is somewhere around 8 to 9% of all the land in Hawaii, and the older shorthand that it is roughly 1 acre in 9 remains close enough to true. It is worth knowing what that acreage actually looks like, because the abstraction hides how varied it is. On Hawaii Island, the largest holdings by far, vast tracts of ranch and forest land, including significant acreage on the slopes of Mauna Kea and in Kau and North Kohala, much of it former sugar and cattle country. On Maui, land above Lahaina and in the Central Valley, again largely former plantation ground, and the campus at Pukalani. On Oahu, the smallest acreage and by a wide margin the most valuable. Land in Kalihi and Kapalama around the flagship campus, holdings in Kakako, the industrial and commercial districts near downtown Honolulu, blocks in Waikiki, and residential land in Windward and East Oahu. On Kauai and Molokai, further conservation and agricultural holdings. The pattern is consistent, and it is the pattern the will created. The trust holds a very large amount of ground that produces very little and requires care, and a very small amount of ground that produces almost everything, which is also why the Oahu commercial portfolio has been the focus of so much attention. When people argue about what Kamehameha schools should do with its land, they are usually arguing about a few hundred acres in Honolulu, not about the 350,000 acres of forest and pasture that make up the great majority of it. It has stayed remarkably stable. Pauahi left about 375,000 acres in the residue of her estate in 1884. 140 years later, after a Supreme Court case specifically designed to break up concentrated Hawaiian landholding, after the Depression, after statehood, after a scandal that removed the entire board, the trust holds within about 3% of what she left. Almost nothing in American life has that kind of continuity. The composition of it is not what people assume. Roughly 99% of the land is conservation and agricultural. Forest, watershed, ranch, farm, lava, coastline. About 1% is commercial, and that 1% which the Trust's Commercial Real Estate Division puts at somewhere over 15,000 acres across a range of properties and ground leases generates roughly a third of everything the organisation spends on education. which is a very clean statement of what the trust is. 99% of the land is a responsibility, 1% of it pays for the school, and the responsibility part turns out not to be a metaphor. On the 8th of August 2023, a fire started on the island of Maui, and by the end of that day the town of Lahaina had been destroyed. More than 100 people died. It was the deadliest wildfire in the United States in more than a century. Lahaina had been the capital of the Hawaiian kingdom before Honolulu. It held the Waiala Church and the graves of Ali'i. It held the largest banyan tree in the country. It was, for native Hawaiians, one of the most significant places in the islands, and most of it burned in an afternoon. The fire spread across land owned by Kamehameha schools. Understanding why requires understanding what happened to agricultural Hawaii, and it is not a story about negligence by any one party, although the litigation has argued about that at length. For a century and a half, the flatlands above towns like Lahaina were sugarcane and pineapple. Those crops required continuous irrigation and continuous cultivation, and a field under cultivation does not burn easily. The Hawaiian sugar industry died. The last plantation on Maui closed in 2016. Across the state, tens of thousands of acres of former plantation land went out of production, and what grew back was not native forest. It was invasive grasses, principally guinea grass and molasses grass, which grow explosively in the wet season, cure to tinder in the dry season, and carry fire faster than almost anything else in the landscape. Somewhere between a fifth and a quarter of the state of Hawaii is now covered in that kind of fuel. So the largest private landowner in Hawaii found itself holding a very large quantity of former plantation ground that no longer had an economic use, in a state where labour and water are expensive, in a climate that had turned drier next to towns. Kamehameha Schools has been sued over the Lahaina fire, along with the electric utility, the state, the county and other landowners, and it has agreed to contribute more than $800 million to the global settlement of those claims. $800 million out of a trust whose entire annual educational spending is a fraction of that. Now hold that against the sentence in Clause 13th about devoting a portion of each year's income to the support and education of orphans and others in indigent circumstances. Every dollar that goes to a fire settlement is a dollar that does not go to a child. And the settlement is not a punishment for wrongdoing that a court has established. It is the price of resolving claims arising from a catastrophe on land the trust holds because a woman died in 1884 and did not want it sold. This is the part of the story that nobody in 1883 could have modelled, and that has nothing to do with anybody behaving badly. Land is not a passive asset. Holding 363,000 acres in perpetuity is not like holding shares in perpetuity. Ground has to be managed, and if it is not managed, it does something. And in a warming climate, what unmanaged former plantation land in Hawaii does is burn. The trust spends substantial sums on land stewardship, watershed protection, invasive species removal, native reforestation, cultural site preservation, agricultural leases to local farmers. It reported spending over $13 million on stewardship activities in a single recent year. But $13 million against 363,000 acres is about $36 an acre, and $36 an acre does not clear guinea grass. Which brings up the question the trust has been circling for 30 years and can no longer avoid, and it is the direct descendant of the question Pauahi answered in 1883. Should it sell? A court-appointed special master has recently suggested that Kamehameha Schools consider offloading some of its land holdings, specifically because holding them creates the kind of liability exposure that Lahaina demonstrated. That is a startling recommendation when you consider its history. The instruction in the will is that the trustees have full power to lease or sell any portion of the real estate and to reinvest the proceeds. Pauahi explicitly gave them permission to sell. But the emotional and cultural weight attached to these particular acres is unlike anything attached to an ordinary endowment, because of what they are and how they came to be in one place. This is not a portfolio. It is the residue of the mahel. It is the land of the senior Kamehameha line, gathered up through a chain of deaths in the 19th century and then, deliberately not broken up. In a place where the great majority of Hawaiians were dispossessed of their ground within 2 generations, this is the one large block that stayed in Hawaiian hands, and it stayed there because one woman put it out of reach of anyone who might sell it. The trust's own language for its relationship to that land is kuleana, a Hawaiian word that means responsibility and privilege at the same time, and specifically a responsibility that is inherited rather than chosen. So when it sells, it does so carefully and it says so. In November of 2025, Kamehameha Schools sold the land under the Royal Hawaiian Hotel in Waikiki for $510 million. The Royal Hawaiian is the pink hotel on the beach, built in 1927, one of the most photographed buildings in the Pacific. During the Second World War, the Navy leased it as a rest centre for personnel coming off the ships. It sits on ground that was part of Waikiki long before any of that, and Waikiki was in Pauahi's estate. Crystal Rose, who chairs the Board of Trustees, said in announcing it that the trust sells land only after much deep and agonising consideration. Our kuleana, she said, is to steward a dynamic portfolio that best serves our trust, and at the same time, we know that our lands carry historical significance, especially this one, which our founder and generations of Alai before her had nurtured. That is a carefully written sentence, and you can see the tension inside it. The board is explaining a transaction and simultaneously acknowledging that the thing being transacted is not, in the ordinary sense, property. And the wider context makes the decision harder, not easier, because of what else is happening to land in Hawaii. The state remains one of the most concentrated landholding jurisdictions in the developed world. Between the federal government, the state, the Department of Hawaiian Homelands, Kamehameha Schools, and a handful of other large private owners, most of the ground is spoken for. What has changed in the last 2 decades is who the private buyers are. They are increasingly not local families or even local companies. They are billionaires, investment funds and technology figures buying at prices no Hawaii resident can approach, often for land they will occupy a few weeks a year. In that environment, every acre Kamehameha Schools releases is an acre that enters a market where the trust is one of the very few buyers who is not going to outbid a hedge fund, and where the likely purchaser is somebody with no connection to the place at all. So the trust holds a set of assets that are simultaneously the source of its income, a source of enormous legal liability, a cultural obligation it describes as inherited, and in the current market effectively irreplaceable if sold. There is no clean answer to that, and the organisation has not claimed to have one. But it is worth noticing what the problem actually is, because it is the same problem in a new costume. Bernice Pauahi Bishop's will does not tell her trustees what to do about guinea grass, or about hedge funds, or about a fire in Lahaina. It could not. What it does is name the people who get to decide. Every hard question in this story across 142 years resolves back into that one design decision. Not what to do, who chooses. Which is why the last part of this story is about a courtroom in Honolulu, and about the sentence itself, which is currently being reconsidered for the first time since the scandal. Before we get to the courtroom, there is a second fight that has been running alongside all of this for 30 years, and it also comes straight out of the will. Kamehameha Schools gives preference in admissions to applicants of Hawaiian ancestry. In practice, for most of its history, that has meant something close to an ancestry requirement. The school's published policy is that it gives preference to applicants of Hawaiian ancestry to the extent permitted by law, and that last clause is doing a great deal of work because the extent permitted by law has been litigated for decades and is being litigated right now. Start with what the will actually says, because it is narrower than either side usually admits. Pauahi's instruction is that the trustees devote a portion of each year's income to the support and education of orphans and others in indigent circumstances, giving the preference to Hawaiians of pure or part Aboriginal blood. That sentence does not say the schools are for Hawaiians only. It establishes a preference, and it establishes it inside a provision about orphans and the indigent, which means a strict reading of her text produces a school whose first obligation is to poor children and orphans, with Hawaiian ancestry as the tie-break, and that is not quite the institution that exists. The Trust's answer to that, and it is a serious one, is context. She wrote in 1883, watching her people die, for a population that was overwhelmingly poor and getting poorer. The distinction between Hawaiian children and children in need would not have looked like a meaningful distinction to her, because they were largely the same children. The legal fights have come in 2 waves. The first was about religion. Remember that Pauahi required the teachers of her schools to be forever persons of the Protestant religion. In 1991, the Equal Employment Opportunity Commission sued Kamehameha Schools, arguing that requiring all teachers to be Protestant was religious discrimination under the Civil Rights Act of 1964. The school's position was remarkable, and it tells you a great deal about how these institutions think. It conceded that the practice was discriminatory. It did not argue otherwise. What it argued was that it was bound by the terms of Bernice Pauahi Bishop's will, and that a trustee is not free to disregard the founder's express instruction because a later statute finds it distasteful. That is the fundamental collision at the heart of every old charitable trust. A will speaks with the authority of a person who is dead and cannot be consulted. Society changes, and the whole value of a trust to the person creating it is that their intentions will survive the changing of minds, including the changing of minds about whether their intentions were good. The second wave is about ancestry, and it is much bigger. A prospective student identified in the litigation only as John Doe, who was academically qualified and was not of Hawaiian ancestry, was denied admission and sued, arguing that the ancestry preference was racial discrimination in the making of contracts under a federal civil rights statute dating to Reconstruction. The case went back and forth in a way that shows how truly difficult the question is. The federal district court upheld the school's policy. A 3-judge panel of the Ninth Circuit reversed and struck it down. The full Ninth Circuit then reheard the case and, by a narrow margin, upheld the policy again. And then, before the Supreme Court of the United States could decide whether to take it, the case settled. The terms were not officially disclosed, though the figure widely reported was several $1 million, which means the central legal question was never answered by the highest court, and it has been sitting there, unresolved, ever since. The case for the school runs roughly like this. The policy is remedial, not exclusionary. It exists to address a specific, documented, historically caused disadvantage suffered by a specific indigenous people, whose population fell by something like 90%, whose government was overthrown with the participation of the United States, and who to this day show worse outcomes than other groups in Hawaii on health, education, income, and incarceration by almost every measure. Congress has repeatedly recognized Native Hawaiians as having a special status, and the trust is private money, given by a Hawaiian woman for Hawaiian children at no cost to the taxpayer. The case against it runs roughly like this. Whatever its purpose, the policy operates as a bright-line racial barrier, and a private school that takes federal benefits, including tax exemption, should not be permitted to run one. A child who is qualified and is turned away because of ancestry has suffered a concrete injury regardless of the intent behind the rule, and remedial classifications on this view should be narrowly tailored and time-limited rather than permanent. A further challenge was filed in 2025 in a legal environment substantially changed by recent decisions on race-conscious admissions brought by a mainland firm. The school's own defenders have noted, with some heat, that the complaint leads with the size of the endowment rather than with any student's experience, and have argued that the wealth is the actual target. This is live litigation, and it is not for a documentary to call. What can be said is that the same document is under attack from 2 directions at once, and that both attacks are aimed at instructions Pauahi wrote personally. And there is a third critique, which comes from inside rather than outside, and which is the most uncomfortable of the 3. Kamehameha Schools is academically selective. It admits strong students. It has become, over a century, one of the most prestigious private schools in the Pacific, with a competitive application process and a low acceptance rate. Read Pauahi's instruction again. Orphans and others in indigent circumstances. A good education in the common English branches, and instruction in morals and such useful knowledge as may tend to make good and industrious men and women, and instruction in the higher branches subsidiary to those objects. She asked for a school for the poorest children, teaching practical subjects, with academic ambition explicitly ranked second. What exists is an elite college preparatory academy. One person quoted during the recent trustee selection process put the challenge in a single question. Her will isn't just take the top kids, he said. Where are the special education kids? That is a hard question, and the institution has not fully answered it. Kamehameha Schools does run substantial programs beyond the campuses, including preschools, scholarships and community resource centres that reach far more children than the 3 campuses do, and those programs are aimed considerably lower down the income distribution. But the flagship is a selective school, and selection is the opposite of what the sentence says. Which brings us, finally, to the courtroom, and to Clause 14th, which is now being examined for the first time since the justices walked away from it in 1997. The system built after the scandal has run for roughly 2 decades. Vacancies go to a screening committee, which advertises, evaluates and recommends, under the supervision of the probate court. It has produced, by general agreement, a far better board than the old system did. Trustees are qualified, pay is reasonable, terms end. The schools are run by educators, But in 2024, the process came under formal review, and the objections raised are worth hearing because they are not about competence. The core complaint is that there is no requirement that the people doing the vetting have any stake in the future of Kamehameha schools, and no requirement that any of them be native Hawaiian, which means that the mechanism for choosing who controls the largest Hawaiian estate in existence can, as currently written, be operated entirely by people with no connection to the beneficiaries. Jan Dill, an alumnus who has pushed for changes, framed it in terms that go well beyond governance. "It is part of our struggle," he said, "for self-determination and controlling our own destiny, rather than having others control it for us." That sentence lands differently once you have the whole history in front of you. Because look at the sequence. In 1883, a Hawaiian woman gave the choice to the Supreme Court of the Hawaiian Kingdom, which was an institution of her own country. In 1900, that became a court whose judges were appointed from Washington. In 1959, it became a court whose judges were appointed by a state government. In the 1990s, it became a conduit for the state's dominant political party. In 1997, it withdrew, and what replaced it was a screening committee with no requirement that anyone on it be Hawaiian. At every single step, the answer to who decides moved further away from the people the trust was created for. Nobody did that on purpose. Each individual move was reasonable, and several of them were reforms. That is what makes it worth noticing. In late 2025, the reviewing judge, Jeanette Castagnetti of the State Circuit Court, indicated she was inclined to grant changes to the appointment process, which means that at the time of this recording, 142 years after it was written, the sentence is open. So let us take the sentence apart properly, because we now have everything needed to judge it, and the judgment is not the obvious one. Start by noticing that Bernice Pauahi Bishop was not doing anything unusual by Hawaiian royal standards. She was doing what her family did. In 1859, Kamehameha IV and Queen Emma went door to door in Honolulu, soliciting subscriptions to found a hospital, because Hawaiians were dying of imported disease and there was nowhere to treat them. That institution exists today as the Queen's Medical Centre, the largest hospital in the state. In 1874, King Lunalilo died at 39 after a reign of barely a year, and left his estate in trust to build a home for elderly and infirm Hawaiians. Lunalilo Home still operates. In 1909, Queen Liliuokalani, the deposed monarch, by then a private citizen in an American territory, put her remaining property into a trust for orphaned and destitute Hawaiian children. The Queen Liliuokalani Trust exists today and does exactly that. And in 1884, Pauahi left everything to schools. 4 rulers or near rulers of one small kingdom, across 50 years, each of them independently converting a personal fortune into a permanent charitable institution for the same people. These are known collectively in Hawaii as the Ali Trusts, and taken together they constitute something unusual in world history. A hereditary ruling class, watching its country be taken and its people die, systematically converting its private wealth into permanent institutions for the population rather than into estates for its heirs. There is an obvious explanation, and it is probably the right one. They could see what was coming. Each of these people had watched the machinery of the kingdom weaken. Government could not be relied upon to survive, and in the case of the last 2 it demonstrably did not. A government can be overthrown in an afternoon. It happened in Honolulu on the 17th of January 1893, and it took a few hours. A trust is much harder to overthrow, because it is not a government. It is a set of legal obligations attaching to property, enforceable in whatever courts happen to exist, under whatever flag happens to be flying. And that is exactly what occurred. The Kingdom of Hawaii ceased to exist. The Republic ceased to exist. The territory ceased to exist. Every governmental structure Pauahi knew was dismantled and replaced twice. The trust never stopped operating for a single day. There is a school that opened in 1887 and has been running continuously ever since. Through an overthrow, an annexation, 2 world wars, a bombing of the harbour, statehood, and the near destruction of its own governing board, it has never closed. Whatever else is true, that is an extraordinary piece of institutional engineering, and it is the thing she got right. Now, the thing she got wrong. The error is not that she trusted the Supreme Court. Given her options in 1883, that was a defensible choice, and possibly the best one available. The error is one level up from that. It is a category error about what kind of thing an institution is. When you write a rule that points at an institution by name, you are making an implicit prediction. You are predicting that the institution will continue to have the properties that made you choose it. Hawaii chose the Supreme Court because it was independent, professional, insulated from commerce and insulated from the legislature. She was choosing a set of characteristics, and she identified those characteristics with a body. But a court does not possess independence the way a rock possesses hardness. Independence is not intrinsic. It is produced continuously by a particular arrangement for selecting and protecting judges, and if you change that arrangement, the same institution with the same name and the same building produces a different result. Her sentence could not see any of that. It named a body. It did not name a property. Compare what she might have written. She could have said that vacancies be filled by persons of demonstrated competence in the management of land, selected by a body having no financial or political interest in the estate. That is a description of a property, and it would have obliged every future generation to go and find whatever institution actually satisfied it. Instead, the sentence said the justices of the Supreme Court, and it kept saying it, in exactly those words, in 1900 and 1959 and 1971 and 1993, while the answer to the question, what is the Supreme Court of Hawaii, changed completely underneath it. This is a general problem, and it deserves a moment stating in general terms because it is not really about Hawaii. Any instruction meant to last forever has to be written in a language that will still mean something when everything it refers to has changed. Constitutions have this problem, treaties have this problem, founding documents of every kind have this problem. And the specific failure mode is always the same. The founder writes down the mechanism instead of the purpose, because the mechanism is concrete and the purpose is abstract, and concrete things are easier to write into a legal document and much harder to argue about later. Then, the mechanism outlives the conditions that made it work, and it keeps operating perfectly, producing the opposite of what it was for. There is a second and subtler part to the failure, and it goes to what a safeguard is. Pauahi installed two protections and ran both of them through the same body. The court would appoint the trustees, and the Chief Justice would receive the annual accounts. That is a single point of failure, and she built it deliberately, because in 1883 the court was the strongest thing she had, and it made sense to put both anchors in the strongest rock available. What that means in practice is that once the court became politically permeable, both safeguards failed simultaneously, and for the same reason. The people appointing the trustees were the people receiving the trustees' accounts. There was no second, independent set of eyes anywhere in the design. You can see the consequence in the numbers we went through earlier. The trustees were reporting the entire trust at about $2 billion, while a single one of its holdings was thought to be worth $3 billion, and the officer legally entitled to receive that accounting was the head of the court that had appointed them. The instruction to publish the accounts in a Honolulu newspaper was the one truly external check she wrote, the one that pointed at the public rather than at an institution, and it is the one that in the end actually worked. Not because it was enforced, it was not, but because the principle behind it, that a trust of this kind owes the public an account of itself, is the principle that 5 people invoked in the Star Bulletin on the 9th of August 1997. The community has lost faith in Bishop Estate trustees, in how they are chosen, how much they are paid, how they govern. That essay was, functionally, the publication requirement of Clause 13th being carried out by other means, 114 years late, by a federal judge, a priest, an appellate judge, an educator, and a law professor, in a newspaper in Honolulu, because the party legally obliged to do it had not. She had written the answer into the will. It just did not say who had to do it if the trustees would not. There is one more angle on this that deserves attention, because it complicates the neat version. It is very easy, from outside, to look at the 1990s and see straightforward theft. That is not quite what the record shows, and the difference matters. Nobody was ever convicted of anything. The allegations of self-dealing were serious, and were made in detail across 3 investigations, and the criminal case that would have tested them was destroyed by a prosecutorial error before any of it reached a jury. What was established in a court to a legal standard is that these trustees were unfit to continue and were removed. and the conduct that produced the most public outrage was not financial at all. It was the destruction of the working environment of a school. The teachers who organised under the name Nakumu o Kamehameha and marched down from the Royal Mausoleum were not marching about Goldman Sachs. They were marching because the place they worked had become, in the words of 5 senior educators, a climate of fear and intimidation, which suggests the real failure was not greed in the ordinary sense. It was the absence of anybody the board had to answer to. Give 5 people control of $10 billion, appointment by a body that will not supervise them, an accounting requirement filed with the same body, no term limits, pay set by a formula they benefit from, and a governance structure they designed themselves that dissolves collective responsibility into 5 private domains. That is not a description of 5 unusual people. That is a description of a machine that would produce the same result with a wide range of inputs, which is, in the end, why the reform worked. The people who rebuilt the Bishop estate after 1999 did not primarily replace the individuals, they replaced the conditions: screening committee, term limits, market rate pay, a real board with a real chief executive, published accounts. Those are all answers to the question Pauahi was trying to answer in Clause 14th. They are just written as properties rather than as a proper noun. So what does the thing actually do now? The endowment stands at somewhere above $15 billion, which was reported at $15.1 billion in 2022 and has been described as above $15 billion in filings and press coverage since. To put that in perspective, that is larger than the endowment of all but a handful of American universities. It is larger than Dartmouth. It is in the range of Columbia and Duke, and it belongs to an organisation that runs 3 campuses and a preschool system in 1 state with a population of about 1.5 million. Around 97% of the organisation's educational spending is funded from that endowment, rather than from tuition. Families at the campuses pay a fraction of what the education costs. The 3 campuses together enrol somewhere around 6,900 students, from kindergarten through the 12th grade, at Kapalama in Honolulu, at Keau on Hawaii Island, and at Pukalani on Maui. Beyond the campuses there is a preschool system, a scholarship arm through the Pauahi Foundation, resource centres on Oahu, Maui, Kauai, Molokai and Hawaii Island, and a set of community and cultural programs that between them touch a substantially larger number of children than the campuses do. And then there is the museum, the Bernice Pauahi Bishop Museum, founded by her husband in 1889, to house the royal collections that had come to her through the same chain of inheritances as the land, is now the State Museum of Natural and Cultural History for Hawaii. It holds the largest collection of Polynesian cultural artifacts and Hawaiian royal objects in existence, along with millions of scientific specimens, which means that the 2 things Bernice Pauahi Bishop and Charles Reed Bishop between them created, out of 1 estate, are the largest private landowner in the state and the principal repository of the culture that land belongs to. Those are separate institutions today, but they came out of the same inheritance for the same reason. A woman with no children looked at what was in her hands, correctly concluded that the political structure around her was not going to survive, and converted everything she had into forms that could outlast it. Now, is it working? That question has to be asked, because the entire justification for an institution holding $15 billion in perpetuity and paying no tax on it is that it is producing something the society needs. The honest answer is a qualified yes with a substantial asterisk. Kamehameha Schools produces excellent outcomes. Its graduates go to good universities at high rates. It has been a central institution in the Hawaiian language and cultural revival of the last 40 years, teaching Hawaiian language and history at a time when the language had come close to extinction, having been effectively banned from schools after 1896. That last point is not small. Hawaiian was suppressed in the education system for most of the 20th century, and by the 1980s there were only a few hundred native speakers left outside 1 small island. The revival of that language is one of the more remarkable cultural recoveries anywhere in the world, and Kamehameha Schools was a significant part of it. The asterisk is the one raised earlier, and it has not gone away. This is a selective school, and the founder asked for a school for orphans and the indigent. The counter-argument the institution makes is about reach. The campuses are the visible part, but the majority of the children the organisation serves are served through the preschools, scholarships and community programs, and those are aimed at families the campuses would never enrol. Both things are true, and the tension between them is the same tension that is in the will, which asks for a practical education for the poorest children and simultaneously creates an endowment large enough to build something far grander than that. There is a version of this story that ends with a moral about greed, and it is available, and it is not wrong exactly, and it is much less interesting than what is actually there. So what is actually there is this. Bernice Pauahi Bishop did not have a great deal of power in 1883. She had refused the only formal power available to her. Her country was being taken apart around her by processes she could see clearly and could not stop. Her people were dying at a rate that would have broken most people's capacity to plan at all. She had no children, and she had personally about 10 months to live, though she did not know the number. What she had was property and a pen, and what she did with them was to make one bet, which is that a legal instrument would prove more durable than a government. She was right. That is the extraordinary thing. She was completely right. The government she knew was overthrown 9 years after she died, and her document is still operating, and a judge in Honolulu is reading it this year and arguing about what it means. But the same bet contained the flaw, and the flaw is a consequence of the bet rather than a failure of nerve or intelligence. Because if you are writing something meant to outlast governments, you are writing for a world you cannot see. You do not know what institutions will exist. You do not know what they will be for. You do not know what words like Supreme Court will mean in 114 years. She wrote the strongest sentence she could. It named the strongest thing she knew, and the strongest thing she knew turned out to be a name attached to a set of arrangements that could be quietly replaced without anybody having to touch her will at all. Which is the answer to the question this whole thing started with. The most valuable thing in that estate was never the land. 375,000 acres is a great deal of ground, and the trust still holds nearly all of it, and it is worth billions. But land does nothing on its own. It sits there. Whatever value comes out of it comes out of decisions, and there is only ever one question that determines everything downstream. Who decides? Bernice Pauahi Bishop's real bequest, the thing she was actually disposing of on the 31st of October, 1883, was the power to make that decision. Everything else in the will is detail. Clause 14th is the will, and for 114 years that power sat in a sentence pointing at a door, and the people who eventually worked out how to walk through it were not thieves breaking in. They were the elected leaders of the state, using an appointment power that a Hawaiian princess had handed to their judges in writing, entirely lawfully, precisely as the document instructed. That is why nobody was ever convicted. There was not much to convict. The mechanism was working as written. The writing was the problem. Which brings us back to the document. The original is not lost, and it is not in private hands. It is in the Hawaii State Archives in Honolulu, a few hundred yards from where she signed it, handwritten on ruled legal stationery. There is a small discrepancy about it that is worth mentioning because it is the kind of thing that tells you something. The attestation clause at the bottom, signed by the two witnesses in 1883, states that the foregoing instrument was written on 11 pages. Kamehameha Schools, describing the physical original in its archive today, says it fills approximately 40 pages. Both descriptions can be accurate of different physical objects, an engrossed copy, and a longer manuscript. But it is a nice reminder that even the most examined document in Hawaiian legal history has small unresolved facts sitting on the surface of it, 140 years in. Go and look at the 14th clause on that paper. It is not dramatic. There is no rhetoric in it. It sits below the passage everybody quotes about erecting and maintaining 2 schools, and it reads like housekeeping. The number of trustees shall be kept at 5. Vacancies shall be filled by the choice of a majority of the justices of the Supreme Court. For most of a century, that was the least interesting paragraph in the document. Lawyers read past it. Historians quoted the clause above it. It was administrative furniture. And then, for about 25 years, it was the most valuable sentence in the state of Hawaii, because it was the only door into $10 billion, and it had been left unlocked in 1883 by a woman who had no way of knowing that the guard she posted at it would one day be appointed by the people who wanted in. And then it became something else again, which is where it is now, because that sentence outlived every single person who abused it. The trustees who came through the door are gone, removed by a court, all of them, inside 2 days in May of 1919. The political arrangement that put them there has been dismantled. The court that appointed them stepped away from the job in 1997 and has never taken it back. And the paper is still in the archive, and a judge in Honolulu is currently deciding how it should work. That is a strange kind of victory, and it deserves naming precisely. The document did not protect itself. It could not. It was defended in the end by people with no legal authority whatsoever, by teachers who organised, by alumni who marched 2 miles down a hill from her grave, and by 5 elderly people who signed a newspaper essay that the biggest paper in the state had already turned down. None of that was in the will, there is no clause covering it. But it is the only reason any of the rest of it still exists, and it suggests something about documents of this kind that is easy to miss when you're admiring the drafting. A sentence cannot enforce itself. It can only describe an intention clearly enough that, if it is ever betrayed, somebody will be able to hold up the paper and point. That is what Clause 14th actually turned out to be for, not a safeguard. A record of what she wanted, in her own words, preserved well enough that 114 years later, a community could read it, compare it against what was being done in her name, and say that the two things did not match. There is one more piece of this story that has never been told properly, and it is not about the trustees or the land. It is about the 4 other estates left by Hawaiian rulers in the same 50-year window, what happened to each of them, and what it tells you that a dying ruling class spent its last decades converting its private wealth into permanent institutions for people it would never meet.